Many thanks, Gustav. Firstly, I would like to thank Europris for providing us the opportunity to briefly present the recommendation on the Commission recommendation on detention. It was indeed adopted on the 8th of December of last year. I will first say something about the background of the recommendation, how it relates to the Council of Europe framework, what the aim of the recommendation is, and what the follow-up to the recommendation will be. The initiative to come up with an EU recommendation on detention was discussed at the Council of Justice Ministers in October 2021, where the ministers almost unanimously expressed that they were not in favor of EU legislation, but that they could support soft law measures such as guidelines or recommendations in the field of detention. That is also why we decided to launch a new study on pretrial detention last year, in order to have an up-to-date overview of the situation in the different EU member states. The study, which was performed by an external contractor, has been finalized in November 22, and a web link to the study can also be found in the recommendation itself. In March 22, we launched a call for evidence, so-called call for evidence, allowing civil society to express their opinion on these matters, for which we received 38 contributions. In May of last year, we launched targeted consultations for the member states, including judges and prosecutors, defense lawyers, NGOs, international organizations, and academics. And we also organized an expert meeting with the member states where there was a large support for the topics to be dealt with in the recommendation at technical level, as the practitioners saw a clear added value in having uniform EU guidance when assessing detention conditions, either in the context of the European arrest warrant or in the context of at national level. Why is more EU guidance on detention-related matters needed? Well, firstly, because mutual trust between EU member states is affected by the bad situation in prisons in some of the member states. As you know, judicial cooperation in criminal matters is based on mutual trust, which, as also emphasized by the European Court of Justice in Luxembourg, does not mean blind trust and must not lead to inhuman or degrading treatment. The study which we performed also demonstrated that there are huge divergences between the EU member states as regards important aspects of detention. For example, if we look at the average duration of pretrial detention in 2020, we see that it varied from 2.4 months in Malta to 12.9 months in Slovenia. If we look at the percentage of people in pretrial detention in relation to the total prison population, we see a range from 8% in the Czech Republic to 45% in the Netherlands. The cost of imprisonment per day in 2020 ranged, for example, from €6 in Bulgaria to 332 euros in Luxembourg. So you see these differences are huge. And this diversity of legal frameworks for detention in the member states and their cross-border interaction have a detrimental effect on mutual trust between the judicial authorities and also on the functioning of our EU flagship instrument in the area of judicial cooperation, which is the European arrest warrant. We see that there are more and more delays and suspensions of execution, and there's also a practice which has developed of seeking assurances from the requesting judicial authorities before executing a European arrest warrant. Our statistics on the European arrest warrant show that there have been more than 400 delays or refusals of European arrest warrants based on fundamental rights issues since 2016. We also see that the European Court of Justice in Luxembourg gets more and more involved. We now have 3 judgments in this area. We have the Aronjosi judgment, the Landmark judgment, then we have the ML judgment and the Dorbantu judgment. And advocate generals in Luxembourg have also repeatedly indicated that it's not for the European Court of Justice but for the Commission in cooperation with the Council and the European Parliament to set common minimum standards. In the case law, we also see that the treatment of vulnerable groups becomes more and more relevant for the execution of the European arrest warrant. We now have two preliminary questions pending from the Italian Constitutional Court, one relating to a person with mental issues and one relating to a woman with a young child, who are both subject to an EAW. We also see that there is an increasing interference of the European Court of Human Rights in Strasbourg with European arrest warrant and detention related matters, which is not necessarily a desirable development. The European Court of Justice in Luxembourg should have the final say on the interpretation of the provisions of judicial cooperation instruments, such as the European arrest warrant. But we see that we have already 3 judgments of the court in Strasbourg directly dealing with the European arrest warrant and relating to the issue of mutual recognition. Right now, 2 judgments with respect to Belgium and 1 judgment with respect to France. Thirdly, the upcoming accession of the EU to the European Convention of Human Rights also calls for a more solid protection of persons subject to deprivation of liberty, where violations of fundamental rights are most likely and most imminent. You might say, we have the European Court of Human Rights and we have the Council of Europe. Why do we need additional safeguards at EU level? Indeed, so far the Council of Europe has been the leading actor on prison matters in Europe. However, the work of the Council of Europe in the area of detention contains a complex, a very comprehensive set of guidelines and recommendations, which have been adopted over the past 30 years. The main documents on prison matters are laid down in the so-called compendium, which contains more than 50 recommendations and is 250 pages long to illustrate. And the basic documents, which are the European prison rules, is already more than 35 pages long. Moreover, the Council of Europe rules obviously apply to the current 46 member states of the Council of Europe, now that Russia is no longer a member, but including states like Turkey and the former Soviet republics. The baseline of the Council of Europe standards is therefore the common denominator of the detention situation in these states, which is obviously lower than the standards we adhere to in the European Union. Moreover, the question is also whether the existing Council of Europe instruments have had the intended effect, as demonstrated by the statistics. The situation in the prisons of a number of EU member states is worrying, not to say critical. We have also heard that from our French colleagues, thereby showing that the member states do not always apply the standards and principles set forth therein. There are several reasons for that, such as lack of political will, lack of budgetary resources for the modernization of prisons that cannot be easily solved. But there's also another reason for which there is a potential to improve, and that is indeed the lack of knowledge amongst practitioners of the basic principles of the Council of Europe and the case law of the European Court of Human Rights. To improve the compliance with human rights standards, it's not enough to only rely on the European Convention of Human Rights, but judges and prosecutors, they must also have up-to-date knowledge of the case law of the European Court of Human Rights. And what we have seen, what we see that there is also a obviously growing number of judgments of the European Court of Human Rights on prison matters. And we noted with our discussions with practitioners that they're not always easily accessible for lower national courts. Access might be difficult because most judgments are not available in national language. Unlike the European Court of Justice in Luxembourg, the Court of Human Rights in Strasbourg has only 2 official languages, namely English and French. And what we also see is that judges tend to focus only on judgments which concern their own member states and do not always take into account important judgments concerning other states, as judgments of the Court of Human Rights are not always disseminated regularly at national level. Some Council of Europe recommendations, CPT standards, are also only available in a limited number of languages. One advantage of the EU recommendation is that it is available in all the EU languages. Now I come to the purpose of the recommendation. One of the purposes of the recommendation is, therefore, as I said, to increase the knowledge within the courts, the prosecutors and the prison administrations on how to use the case law from the Strasbourg Court and the Council of Europe recommendations in the everyday work and in executing judgments. Indeed, judges and prosecutors have a decisive influence in sentencing and therefore also in protecting basic human rights. Another aim of the recommendation is obviously to establish a non-legislative, non-binding framework as a minimum benchmark in all EU member states. And member states are free to set higher standards at national level if they wish to do so. In the context of EU judicial cooperation, the development of these principles is intended to avoid impunity. And then I'm mostly thinking of European arrest warrants, which are currently not executed because of poor detention conditions, but at the same time to protect the dignity of the person who will be imprisoned as a result of a European arrest warrant, as a transfer under an EAW is already impacting the basic fundamental rights, as the prisoner does not speak the language and is devoid of close contact with his family and relatives in a foreign country. However, it should be noted that the minimum standards should not only apply to persons who are subject to European arrest warrants, but to all those persons detained in EU prisons, also in order to avoid discrimination and to avoid the phenomenon of so-called prison shopping, meaning that people subject to a European arrest warrant are better treated than national prisoners. The idea of EU standards that encompass all the details of prison law now contained in the European prison rules was considered to be too ambitious, but there was an urgent need for consolidation of the various recommendations into a coherent whole. This approach has also been reflected in the recommendation, which starts with general principles, which are very similar to those of the first part of the European prison rules. It then summarizes in more general wording the most important substantive ideas contained in the European prison rules, but that does of course not contain every detail of the rules. So the Council of Europe European prison rules will therefore continue to operate with enough detail to guide practice generally and to serve as a basis for interpreting the European Convention of Human Rights and the mirroring provisions of the EU Charter of Fundamental Rights. For the very specific aspects of prison life, for example, the ability of prisoners to take part in public life as voters or electors, the more detailed recommendation of the Council of Europe would obviously be leading. What are the next steps to the recommendation? The recommendation contains an obligation for the member states to inform the Commission on the follow-up at national level, and they need to do this within 18 months after the adoption of the recommendation. Based on this information, the Commission will monitor and assess the measures taken by the member states, and the Commission will submit a report to the European Parliament and the Council within 24 months after its adoption. And to assess the progress made by the member states after 1 year already, the Commission will suggest to put the topic on the agenda of the Council of Justice Ministers of December of this year. For the substance of the recommendation, I invite you to have a look at the recommendation yourself. As you might have seen, it is divided into two parts. One part on procedural rights in pretrial detention, and another part on material detention conditions. It contains provisions relating to the use of pretrial detention only as a measure of last resort, the application of alternative measures to detention, periodic review of decisions on pretrial detention, the limited grounds of imposition of pretrial detention, thereby making, for example, sure that foreign nationality is never taken as the sole basis for determining the risk of flight. As regards material detention conditions, we included provisions on minimum cell space in square meters, on the time spent outside the cells to engage in work, education, and recreational activities. We have provisions as regards detention monitoring and the handling of complaints of prisoners by independent monitoring bodies. It also addresses issues such as social reintegration of prisoners and special measures to address the issue of radicalization. Finally, you will see that it covers also the needs of certain groups of prisoners which have special needs or are particularly vulnerable in situations of deprivation of liberty. I will stop here. Many thanks for your attention, and I will be happy to answer any questions you may have. Thank you.
Thank you, Jesca.